Hey gang, alright, I'm going to do this short video on the Supreme Court cases. We'll go over them in class and we'll go over them in more detail in class, but I want to make sure everybody has the information they need for the exam. We'll probably have... You'll need to know these in more detail for the final exam because I'll definitely reference them, but we don't need that. We'll just do some brief stuff here. So, okay, one key term for a court case, amicus brief. An amicus brief is what's also known as a friend of the court briefing. We talked about how they're parties to a court case. At the Supreme Court level, most of the arguments are delivered via written arguments. At the Supreme Court, most cases generally have oral arguments for only an hour. 30 minutes for one side, 30 minutes for the other side. And generally those are just for the justices to ask questions of the lawyers based upon their written arguments. So the lawyers will, in a Supreme Court case, will submit, long written arguments on behalf of their client or in favor of their case, whatever. Before their actual case is heard before the court, before they go before the justices, the justices will review the case, will review the written documents, and then ask, questions to the lawyers about them, challenge them, things like that. And there can be follow-up discussion, follow-up written arguments from the lawyers, things like that. But an amicus brief is court briefs that are delivered to the justices, much like the briefs delivered by the lawyers to the justices. However, amicus briefs come from people that are not directly a party to the case. So, what this means is the Supreme Court, they're justices, they're 9 justices, and they're not experts on everything. They know stuff about constitutional law, and American government and stuff, but they are not experts in climate change and bioethics and race relations and urban planning. In any of these fields, they may have to rule on any number of these issues. Think of any issue, and they may have to rule on it, and they're probably not experts in most of those things. So, what amicus briefs do is the court accepts amicus briefs from people who are not a party to the case, again I say that, but who may have some area of expertise on the issue, or may be able to provide the court a broader look at the issue. So the court may be looking at the constitutionality of the Affordable Care Act and expanding Medicaids to states, and one side says they don't want to expand Medicaid, the other side says they do want to expand Medicaid. The court, though, will not only be interested in what both those sides say and why they say it, but they're also going to be interested in what other people have to say. So, for example, a poverty rights group could come up and write an amicus brief to the court describing the effects on poor people if they don't get the medical care that Medicaid would provide. There may be health experts. The health experts will provide an amicus brief to the court talking about what the effect on public health or what the effect on health economics would be, depending on what the court would rule. Now, there are going to be interest groups to these different sides. So the American Medical Association, a conservative interest group, could submit an amicus brief talking about issues that they're interested in with regards to the case and what they think the court should rule, how they think the court should rule in the case, why, and what outcomes do they expect from the court depending on which way it rules. Like, what are the real world outcomes, and why those are good and bad, and why they think that way. Then Physicians for Universal Healthcare, a liberal healthcare group, may also submit an amicus brief to the court talking about what they're concerned about with the Affordable Care Act case, what they think are the most important issues and what are the important issues to them, what the outcome of the case will give. So they'll say, court, we think you should rule this way. This is what we expect the law to do. This is what we expect if you rule the way we want you to. What will happen? Here are the reasons why. If you rule in favor of the other side, this is what we think will happen, and this is why we think that's bad. So amicus briefs are briefs delivered by people who are not a party to the case directly, but who have some relevant expertise, some interest, and can deliver to the court a broader range of arguments, of opinions, of effects of how the court's ruling might affect, the society. That way the court won't make a dumb ruling, theoretically. Now, so the court may, a law may pass that it could be obvious to people that it's unconstitutional or whatever, but and somebody sues saying it's unconstitutional, gets to the Supreme Court. Most of the justices are like, yeah, this is unconstitutional, but then an amicus brief could be filed by somebody that says, if you strike down this law, everybody under the age of 5 will die. That's a, very extreme and strange example. I don't know what law would pass, but, let's say it's a law that's clearly unconstitutional. However, this amicus brief shows how this very extreme negative thing would happen if the court were to rule against the people that want the law to be in place. And, the ruling, if the court ruled this law was unconstitutional, it would mean everybody under the age of 5 would die. The court in that case would look at that and say, you know what, this law may be, unconstitutional in some way, but the public policy outcomes, the outcome to society is so extreme, so insane, such a bad thing that we're not going to strike down this law, because everybody under the age of 5 dying is way worse than whatever this unconstitutional law is that I invented in my head that somehow would cause people to die. So that's what an amicus brief is. All right. When the court rules, what you'll rule in court cases. Oh, did I mention these are on some of the court cases? Yeah, I think I did. Anyway, what you'll read in court cases is you'll read opinions written by the justices. You'll read a majority opinion, a dissenting opinion. You may read multiple dissenting opinions, and you may read concurring opinions. So a majority opinion is the majority reasoning by the court as to why they made the ruling they did. Now, there's some people who may agree with the majority ruling's outcome. In the ACA, they may agree that the ACA is constitutional and agree with that outcome. However, they may have different reasons for making sure, the outcome that happened came. But they may have different reasons for it, and they may want to express that. So they'd release a concurring opinion. they may agree that it's good that the fines for those who don't have health insurance sort of stay in place, that is part of the Affordable Care Act. However, those there could be a concurring opinion that says, listen, the opinion of the court was wrong. The government does not have this authority, or it's not a tax authority issue. The government has the authority to require everybody to have health care under the Interstate Commerce Clause, for example. The court's opinion was that the government could tax people who did not have health insurance, but they couldn't, quote unquote, require people to have health insurance. The government tried to say that under the Interstate Commerce Clause, they could require people. Anyway, the majority opinion says it's about taxes and the government can tax people who don't have health insurance. A concurring opinion could say, well, yeah, the government can tax people who don't have health insurance. However, the real reason that I support this sort of outcome of keeping this fine in place is because I think the government has this broad authority to require people to have health insurance. So do you see the difference there? The outcome's the same. The fines, penalties stay in place for those who do not have health insurance. That's put in there by the law. However, the majority opinion was the government can do that under its authority to tax, but cannot require people to have health insurance, but it can tax people who do not have health insurance. However, another justice could say, well, actually the government has this ability to require people to have health insurance, and the way it enforces this requirement is through this penalty, this fine of people. It's not a tax, it's a penalty. Anyway, that would be a concurring opinion. So yeah, Bradwell v. Illinois. This was a case, it's always good to look for a case, what year it was decided in and how it was decided. Bradwell v. Illinois was an 8-1 decision. It was made in 1873. The basic outline of the case is Bradwell, what's her first name? Myra Bradwell, applied for the bar in Illinois. She was, for all intents and purposes, smart person who was able to be a lawyer if Illinois would just admit her to the bar. Illinois says, you're a woman, you cannot be a lawyer because you're a woman, and we have laws saying that you can't be a lawyer. She sues, citing the Equal Protection Clause, the Privileges and Immunities Clause in the Constitution, and it was Equal Protection Clause and Privileges and Immunities. She says, listen, men are allowed to be lawyers in Illinois. I should be able to be a lawyer in Illinois. It's violating equal protection, that men and women are treated differently. And also, the Privileges and Immunities Clause in the Constitution says that there are rights citizens have. Citizens have privileges and immunities that cannot be abridged by the states. And that being a lawyer was one of the sort of fundamental privileges that citizens have that could not be abridged by the states. Unless, maybe the person committed a felony or something. The court disagreed, saying that the right to be a lawyer was not protected by the Constitution, that nobody had the right to be a lawyer, and the Equal Protection Clause did not apply because at that time the court was reading the Equal Protection Clause as being equal application of the law, not a clause that extends rights to people. So they looked at the case, they said, Bradwell, you are being treated equally under the law, or the law is being applied the same to you and everyone else. It's not you that are not allowed to be a lawyer. It's all women who are not allowed to be lawyers. You're a woman. You, just like all of the women, are not allowed to be lawyers. The law is being applied equally to you. That's what the main court opinions was. The reason, though, this is interesting, this court case is really interesting, is because of Justice Bradley's concurring opinion. He agreed with the court for the most part, but wanted to add his own 2 cents. And his own 2 cents involved saying that women should not be lawyers because they operated in a separate sphere as men did. They should be in the house. That being a lawyer was sort of antithetical to being a woman. Women were timid, delicate, nurturing. They did not possess the qualities to be a lawyer. Man's role is to protect a woman, and women should stay at home. I mean, I feel like it's fun. It's over and over again, etc. We'll talk about it more in class, but that was kind of his upshot, and we'll talk about this idea more when we get to the women's in politics section. But that was the opinion, and think to yourself, should women be allowed to be lawyers? And good framing question. Or this is a good example of framing, and why it's so important. What are we assuming and not assuming when we ask the question, should women be allowed to be lawyers? How does that frame societal, sort of what's natural in society, what we consider to be, assumed to be correct without question, and what are we questioning, and how does our asking the question, should women allowed to be lawyers, how does that paint women in a certain way? What does it make us think about women? How does it sort of get us to think about the role of women in society? The next court case, Loving v. Virginia, this was in 1967. This court case ruled that bans on interracial marriage were unconstitutional. What happened was a black woman and a white man, Mildred Jeter, black woman, and Richard Loving, the white man, they got married in D.C., where they allowed interracial marriage. Virginia did not allow interracial marriage. They moved back to Virginia after getting married in D.C. and lived together. Part of Virginia's interracial marriage, or ban on interracial marriage, was that a couple could not live together as if they were a man and woman while being of the different races, essentially. They were arrested. They were sentenced to a year in jail. However, a judge said that we won't enforce this 1 year in jail thing, but you have to leave the state for 25 years. The judge banished them from Virginia, otherwise they would spend a year in jail. So they moved to D.C. and pursued a court case. At several different levels in the Virginia state courts where they first started the lawsuit, they were struck down, or the couple was told, no, the ban is correct. For example, this was a fun statement from one of the lower court decisions. It's on slide 16 of the Supreme Court cases. Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. And the fact that he separated the races shows that he did not intend for the races to mix. Wow. That was in like 1963, 65, something like that. Not very long ago. Yeah. So that's what we have. In 1967, the court case that struck down the Virginia ban on interracial marriage, there was an amicus brief filed on behalf of Virginia or in favor of Virginia. So we talked to amicus briefs can be filed with the court in favor of one party or the other, helping support the party's claim. So the amicus brief, there was one filed in favor of Virginia, helping support the claim of Virginia. Who filed that amicus brief? Drum roll. North Carolina! Yay! North Carolina didn't like interracial marriage either in 1967 and wanted Virginia's interracial ban to stand. Ban to stand. Okay. The good news is the Supreme Court struck down the ban on interracial marriage 9-0. It was a unanimous decision. They said the 14th Amendment does apply to marriages, the equal protection does apply to marriages, and the Virginia state's argument that the ban was okay because they were applying the ban equally, both the white man and the black woman were punished the same under the law, thus it was okay under the 14th Amendment because there was equal application of the law. The court rejected that and said, no, equal application is not the way we should look at the 14th Amendment. We should look at it as equal protection, that everybody enjoys the same protection under the law, and that the 14th Amendment is about extending rights to more people and not as a method to restrict rights. Now, one of the court cases that Virginia cited in support of their interracial marriage ban was Pace v. Alabama, which was ruled on in 1887, I believe was the year, 1887. It was right around there. Anyway, Pace v. Alabama, the Supreme Court ruled in favor of Alabama. The case was somebody somehow walked in upon a white person and a black person doing it. They were having sex, and so they were both sentenced to jail or whatever the punishment was. It's written in the court case somewhere. The thing was, the white person and the black person were both subject to the same punishment. If it was 6 months in jail, they both got 6 months in jail. The sentence was appealed, saying that the ban on people having sex with each other was wrong, but the Supreme Court said, no, the state's okay because the state applied the punishment or the law equally to both the white person and the black person. If the state, for example, would have sentenced the black person to a year in jail and the white person to 6 months, then the state would have had a problem. They would not have been, that would have been in violation of the 14th Amendment according to the court at that time, because they were concerned with equal application. However, because the punishment was the same, the law applied to both people the same, it was okay. Virginia cited that case, and this is shocking, I think. Virginia cited a case from the 1880s where a white person and black person were caught having sex and then sent to jail because of it. And the Supreme Court ruled it was okay because they were both punished equally, and the state of Virginia thought that was okay. This was 40 years ago. Think, that's shocking. That was only 40 years ago. 17 years before I was born. How old am I? 13 years before I was born? Something, whatever. It was under 20 years ago. 12 years before I was born, I guess. If it was 40 years ago. Whatever. Doesn't matter. It would have been 50 years ago, actually, because... Yeah, okay, 50 years ago, fine. Yeah, then 17 years before I was born. Anyway. Okay. That's Virginia. And in 1967, that's when interracial marriage became firmly legal across the country. Finally, West Virginia State Board of Education v. Barnett. So in 1943, this was when the court decision was made. However, it's fun because this court case repeals a decision that the Supreme Court had only made 3 years earlier. So Minersville School District v. Gobbets, the Supreme Court ruled that it was okay for a school district to require students to say the Pledge of Allegiance. What happened in that case was family of Jehovah's Witnesses sued, saying that saluting the flag violated their sort of religious beliefs. So Jehovah's Witnesses believe, where did I put it? Trying to find the biblical passage. Basically, if you salute the flag, if you pledge allegiance to the flag, it's a worshipping a false idol, and Jehovah's Witnesses look at the flag as a false idol, and you're worshipping something other than God if you pledge allegiance to it, and so it violates their religious beliefs. It's Exodus chapter 20, verses 4 and 5. Thou shalt not make unto thee any graven image or any likeness of anything that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. Thou shalt not bow down thyself to them nor serve them. Okay, so that's what Jehovah's Witnesses, they look at that and they say, the Bible's telling us not to pledge allegiance to the flag. So they sue and they lose. The Supreme Court says it's okay to require Jehovah's Witnesses to salute the flag because it's, not specifically done to try and violate their religious freedom. However, they accept a case only 3 years later, like I said. This is West Virginia v. Barnett in 1943, and they overturn their previous decision. The Supreme Court says that they made a mistake 3 years ago, and in a ruling of 6-3 say that the requirement that Jehovah's Witnesses salute the Pledge of Allegiance, or salute the flag and recite the Pledge of Allegiance, is actually a violation of their free speech rights, and they didn't say it was a violation of their free religion rights, which this other part also has a important meaning for today, in today's court case. So the court, I love this opinion because there's a lot of political philosophy in there. The court talks about how, listen, how can we enforce loving of the country, essentially? The argument is pledging allegiance to the flag helps instill love of country. The court says, are we really such a crappy nation? Are our institutions really so terrible and really have so little to recommend themselves of that we have to force school children to pledge allegiance to the flag in order to make sure they love the country? The court's opinion says that suggests that we are a terrible, terrible nation. essentially. They do not buy the state's argument that it will, that it's a proper way to build community feelings, patriotism. The court talks a lot about how Jehovah's Witnesses have been discriminated against, and that doesn't help communities from getting together and being all happy. We'll go over this more in class. The important thing, though, to know about this case is the court ruled in the Jehovah's Witnesses' favor, but not on the basis of religion. I'll say that one more time. The court ruled in the Jehovah's Witnesses' favor, not on the basis of religion, even though this is a court case revolving around religion. The Supreme Court said that if we allow people or entities, whatever, to violate U.S. law because of even sincerely held religious beliefs, we're inviting anarchy into the nation. That just because you believe something, that does not mean that you should be able to, something is part of religion does not believe you should be able to violate U.S. law. So the argument by the Jehovah's Witnesses that it violated their religion was not good enough. The court, though, said it does violate your free speech. And we can't have people's free speech being violated by the government in this way. So we're going to say that nobody across the nation has to salute the flag or say the Pledge of Allegiance, because that is a clear violation of people's free speech rights. The first right in the Bill of Rights. Anyway, I say this is important to note, the justice's reasoning on the fact that religion did not play a part in their ruling, and they go to great pains to say that, because with the Affordable Care Act, so we talked about a little bit in class, there's been a lot of court cases against it, saying that requiring the requirement of businesses to provide birth control to its employees violates the business's religious freedom, and violates the owners of those businesses' religious freedoms. This court case, along with just about every other court case, Supreme Court case in American history, would look at that argument and say, that's some BS. If we were to allow you to violate U.S. law because you say you have a sincerely held religious belief, that just invites anarchy. Because now anybody can say they have a sincerely held religious belief, and they don't have to follow any laws. So what's the point of having laws in a nation where everybody can say, I believe this, my religion teaches me this, therefore I don't have to obey this law. That's not a good country to live in, and they also talk about how we're a secular nation, not a religious nation, or at least our laws are secular. People can be religious, but as a institution, our laws, our government is secular, should not be based on religion, should not pay mind to religion in that sort of way. To do so would be to support religion in one way or another. Thus, we can't provide religious exceptions to things like this. So, fun connection to today, and I think a fun court case, and we've talked about the Pledge of Allegiance some. Again, if anybody forces you to say the Pledge of Allegiance or salute the flag, they are in violation of the United States Constitution. So, fun times. And hope that was useful. For this court case, again, remember, the court ruled in favor of Barnett, the Jehovah's Witness family, not based upon their religious beliefs, but on freedom of speech. Okie dokie. See y'all soon.